Lawyers who have represented a murderer or serial killer, what was it like? Story 1. My dad was a lawyer and represented several murderers. One of the more interesting anecdotes is from my mom. When I was about 2, my dad hires an old client of his to babysit me. She is an older lady who watches me a few times. Later, my mom discovered she was charged with the takedown of her husband, ended up convicted of manslaughter, and was out after a few years. Mom gave my dad a lot of hell for allowing a murderer to babysit. His response? Well, it's not like Curious Pursuit is going to cheat on her. Story 2. I have defended 4 people charged with takedown in their trials. All 4 were found guilty. One very likely did it, but there may have been mitigating circumstances we were not allowed to introduce at trial. One probably did it, but I'm not sure he had the required intent to be found guilty of takedown. One certainly did it, but I truly believe at the time he was insane. The last one is the one that I think about still, sometimes in the middle of the night. No physical evidence, no confession, no weapon. He was still found guilty, but I have my doubts. Answer. I sat on a jury for someone like the second you described. He did it, but I don't think he was trying to take down anyone. I think he was scared for his own life. His lawyer was awful. She practically handed the case to the prosecutors. It was really sad. He was a substances user turned runner for the big kingpin in town. He used the product and never paid the kingpin. The kingpin was hunting him and told everyone that he was going to eliminate the runner. The runner got ambushed by a friend and shot the kingpin. Everyone in the courtroom agreed that the town was a better place without the kingpin in it, but you can't just take someone's life. Story 3. I've represented 3 murderers, but not in the criminal cases. 2 of the cases were where the murderer was sued by the family members of the person they eliminate. The insurance companies denied a defense because intentional acts are almost always excluded from insurance policies, and the family of the murderer hired my firm to try to obtain insurance coverage. I never met the criminals, and we were able to successfully resolve the matter so that the families receive some compensation. We do this all the time in civil cases, usually by us coaching their attorney how to properly plead the case to make the insurer responsible for having to pay for a defense, and then the insurer decides that it is cheaper to settle than it is to defend. The third time he had committed takedown as a young man, really it was a bar fight that went too far, was convicted of second-degree takedown, sentenced to 20 to life, was model prisoner, paroled at 14 years, did his time, and had started a successful business as a real estate developer. Then, in 2006, he was driving his truck, blew a tire, and veered into traffic, causing a significant crash. He hired us to sue his insurer when the insurer denied coverage. I didn't know until I was prepping him for his deposition that he had been a murderer, and I never would have guessed it in the first place. Fortunately, that didn't come out when he was deposed. We were able to recover a significant amount of money, mid-7 figures, for him, which he used to pay the people who he hurt when his tire blew out. Absolutely the nicest guy you could imagine. A decade later, he still pops into the office and brings us donuts occasionally. Story 4. My father has been a criminal defense attorney for 30 years. He no longer takes those types of cases, homicide, serial takedown, etc., because they do take an enormous toll on your mental well-being. My father is as calloused and confident as they make them, so if he is willing to admit that it rattles even his conscience, it must be some serious shoot. Apparently, during one of his first cases back in his 20s, he had to represent a takedown who he believed to be 100 guilty, could not go to sleep the night before trial, stayed up vomiting and crying all night long. Answer. My sister is a public defense lawyer. She was defending a guy who was accused of the violation and takedown of a 12-year-old girl. She definitely thought he was guilty, but because he's on legal aid, she was assigned to him. She told me she would go home and scrub herself after dealing with him. He was that grimy and sleazy. The whole trial took a huge toll on her, especially after she was pictured in the paper with him as his lawyer. People sent her passing threats, and ironically, violation threats. Story 5. Terry Gross on NPR's Fresh Air interviewed the famous criminal defense lawyer Richard Racehorse Haynes. He told of a time when he got someone acquitted. As the jury returned to the courtroom, he could tell from the various nods in his direction and smiles on the faces of the jury members that he had won the case. He leaned over to the defendant and told him the jury had been very kind to him and that he should thank them. The acquittal was announced. The judge asked the defendant if he had anything to say. He rose and announced, "I'd like to thank the jury, and I promise I will never do it again." Answer: I think it's important to note that this was for a trial of a man accused of stealing money from a bank. If you click on the link Yutha Mighty Gwar posted and then go to roughly 35 minutes in the video, he tells the story. Not that stealing money is okay, but he didn't stand up in court and admit to take down either. LOL. Edit. Thanks UpuckFan21 for the catch on missing part of the username I linked. Story 6. I never represented a serial killer that I know of, but I represented quite a few murderers, and the answer is, they're much like the rest of us. There is no mark of Cain. Some of them have explosive tempers, but under U.S. law that tends to mitigate the offense by negating premeditation. The rest were just swept away by adult beverage, substances, jealousy, narcissism, lot of that, and other unpleasant personality traits that most people will exhibit from time to time. Everybody gets angry. This common humanity means it's possible, indeed incumbent, on any criminal lawyer to develop good sentencing advocacy skills, meaning trying to find the best in people, then trying to make that core humanity clear to the court. Murderers need this most of all, regardless of whether the lawyer gets shoot for arguing that murderer was a poor, abused child. Fudge it. They often were poor and abused, and it's your duty to make use of that evidence. Answer: just curious. Do you think that a lot of people, given the wrong mix of circumstances, would be capable of takedown? I find it interesting that you say they are much like the rest of us. You hear stories of people who knew serial killers and takedown who often say they had no idea. Nothing hinted they would commit hideous crimes. I just find it hard to wrap my head around otherwise normal people getting horribly caught in the moment and acting totally out of character and eliminate someone. I would be interested to hear your thoughts. Story 7. I helped represent 3 murderers, all on passing row, 1 at trial, and all 3 in post-conviction relief situations. They were interesting. I worked for one of the top passing row defense attorneys in the nation. All of these men had mental health issues which their original attorneys failed to explore and use as either a defense or as mitigation at sentencing. While I didn't feel any sympathy for what they did, including a 6'7", 270s Rita B, dude who looked like an NFL tight end, or linebacker who brutally take down an old lady with a screwdriver over a $200 Social Security check, it was sad to see how their original lawyers had failed to adequately protect their rights. At the end of the day, it's all the same whether I'm representing a dumb college kid in municipal court who got too tipsy at the bar and started a fight with a bouncer, or someone accused of takedown. Story 8. Just a regular murderer, not a serial killer. It was fine. Here's the thing. You get into criminal defense law, you have to get used to the idea that you're going to be defending criminals. The criminal justice system isn't full of innocent people being railroaded and waiting for Matlock to show up and trap the star witness into admitting that she's really the killer. A really tiny number are factually innocent. A decent number did exactly what the police say they did. In the latter case, you're putting the Crown to its proof, testing the evidence, testing the chain of custody, or the witnesses, recollection, or whatever. Looking not for a smoking gun of innocence, but for a reasonable doubt. You're trying to get the best outcome possible for them, which might be a not guilty verdict, but might be a conviction or a guilty plea on a lesser included charge. You do your best for everyone, right up to the limits of the law and the code of conduct. If you can't do your best because you're conflicted about representing criminals, then, shocker, criminal law might not be for you. My only murderer was convicted of manslaughter. It was a fair outcome. Answer: a really tiny number are factually innocent. A decent number did exactly what the police say they did. This is my experience in the field. Most of my cases are federal, so for them to charge someone, the evidence is usually overwhelming. The questions of the statutes and application of the law is the gray area which will prevent prosecutors from bringing charges at all. There are a lot of times where the client did something, but you are working to make sure the punishment fits the crime. Story 9. Lawyer here. I was a public defender for 5 years, now private practice because I make 10x as much. I'm going to speak more generally because a lot of homicide cases are just not that interesting. Half the time, the defendant brags about how this is what happens when you fudge with me, and thinks that doesn't implicate him, he confesses. Or, there's overwhelming evidence. I have no moral qualms about defense. It's important, and the Sixth Amendment guarantees the right to counsel. Some have said that the reason it's important that defendants have access to counsel because it makes sure any convictions stick. I find that line of reasoning utter bullshit. The reason I work in criminal defense is twofold. One, it is, quite literally, the only way the system works. The system will become corrupt with no criminal defense. Two, the system is completely biased against the defendants. Without counsel, they will be completely chewed up and spit out, and their punishment will extend far beyond the magnitude of the crime they may have actually committed. One example of how the system is biased against the defendants can be seen in overcharging. You have no idea how common overcharging is. When I was a public defender, it happened about 99% of the time. The state would overcharge just so they have an extra tool to use during plea negotiations, and they usually got away with it because most public defenders are overworked. Another example of the systematic bias is that prosecution doesn't always play by the rules, and you need someone on the defense to call them out on it. I was once defending a young gentleman who had a long list of charges. He'd been in and out of the justice system his entire life, and most recently, at the time, he had allegedly broke into several vehicles, stole the radios, and assaulted one vehicle owner that caught him. The prosecution called a community member that lived near him to the stand, a community member that had no standing to testify, and they would have gotten away with it if it weren't for me. They're sneaky, and obviously, he didn't know they didn't have standing to testify. I guess that doesn't answer your question. The TLDR is, I have no moral qualms about it, but all my murderer or serial killer cases have been boring and none have been high profile. Answer: murderer or serial killer cases have been boring and none have been high profile. My personal attorney was a former prosecutor, did mostly white-collar crimes from my understanding, as we just use him for business purposes. If I was ever charged with a crime, someone else at his firm would defend me, I assume. But we are friends, and he's told me that when he first started off in the prosecutor's office, he did a couple takedown cases, said they are boring and take fudge forever. The guy was dead to rights, overwhelming evidence, and the entire case was basically the other side trying to get evidence thrown out, get evidence admitted that might lead to mitigating circumstances. And in one specifically, it was basically months of, yeah, my client did it, but that doesn't constitute what he was charged with. He was telling me that most takedown are actually handled by the public defenders. Because of the fact that the cases take so fudge long, most people can't afford a private attorney. And the private ones that have the experience either do other kinds of defense work that makes way more money or charge. So fudge much that the only people who can afford them are really wealthy. Story 10. I left the job before I qualified for the state's takedown list, but I stumbled onto a takedown case through a client who was out on bail for a nonviolent substances offense. Thus, for about 3 weeks, I did technically represent somebody who was going to be charged with takedown, even though I didn't get assigned the takedown case once it was put together. The short and legal to disclose version is this. It was sad. Just sad. The facts of the case were sad, and not in the, oh no, somebody died kind of way, but in the, Christ, this is just a bunch of drugged out losers with a broken handgun and somebody ended up dead, possibly even by accident kind of way. My client was just one of said sad, drugged out losers. He wasn't on the business end of that broken handgun when it went off though, so he had that going for him, which was nice. Everything about his life was sad. Everything about my attorney-client relationship up until that point was sad. Inability to contact or find him, followed by a string of phone calls to my home phone, which I never gave out during office hours, with no name or contact info attached. I had to infer it was him by his voice. There are always exceptions, of course, but most of the time, one-on-one takedown is a sad, poor person crime. Even the hardest clients are caught up in a situation that most educated professionals, like, say, attorneys, recognize as the farcical churning of desperate fish in small, dirty ponds, where calling one of them big might as well be an insult for how meaningless and darn it is. In those rare instances when you get a client who's a genuine shark, a horrifying, vicious, unrelenting predator, it's difficult to ignore the fact that but for a set of wealthy parents, he'd be out on a multi-decade, legalized crime spree, wearing a nice suit and spreading the suffering around far and wide, with a nice set of prescriptions for his substances and enough money to sweep a few aggrieved partners, intimacy, or otherwise, under the rug. Story 11. One of my law professors represented John Wayne Gacy on his appeal and has represented many alleged and convicted murderers. He said it's really easy defending someone you know or think is guilty because all you're there for is to make sure the state proves its case and follows the rules. When you have someone you believe to be innocent that gets convicted, though, that was what keeps him up at night. So, apparently, it's not tough representing actual killers. Story 12. I get asked this a lot. I have represented horrible people accused of horrible things. But the fact remains that they are owed a fair trial, and the state still needs to prove the facts beyond a reasonable doubt, which is difficult. If the state cannot meet their burden, the accused goes free. This is our system. Story 13. From a legal perspective, most of such cases are pretty clear-cut and therefore rather boring legal-wise. The most interesting cases are those where the law and facts are in a conflict. For instance, cases where the letter of the law says the defendant should be punished, but common sense says he doesn't. Those are hallmark cases that shape a legal system. A case where Stabby McMurderer stabs 8 people isn't all that interesting. Most of the time there's a lot of evidence against Stabby. Stabby probably confessed or is gloating about his crime. If he is found sane, he gets put away for life. Cases. However, where the judge runs into a problem are interesting from a legal perspective. A famous case in the Netherlands was one of a veterinarian that knowingly exposed cows to a certain mild form of cowpox, a bovine disease. Knowingly spreading livestock diseases is banned, so he should be punished. However, the veterinarian argued that he exposed the cows to the bovine disease in order to immunize them to a certain more aggressive form of cowpox. This was a problem legal-wise. The veterinarian admitted he committed the crime, spreading a disease, but he argued that he did it with the aim of preventing worse. In the end, he was acquitted. The court had to accept that sometimes a certain offense cannot result in a conviction if the defendant's aim was just. From a strictly legal point of view, such cases are rather boring. Then again, I am not a lawyer. I studied law and legal philosophy. These are just my 0.02. Answer: the most interesting cases are those where the law and facts are in a conflict. This cannibal case comes to mind when reading this, if anyone's curious about when a takedown case gets more complicated legally. Link. The unprecedented case has proved problematic for German lawyers who discovered that cannibalism is not illegal in Germany. Instead, they have charged Maiwes with takedown for the purposes of intimacy pleasure and with disturbing the peace of the dead. The accused, however, has a unique defense, that his victim actually agreed to be eliminated and eaten. Crucial to the case is a gruesome videotape made by Maiwes of the entire evening, during which Brandes apparently makes clear his consent. Story 14. Worked on a case where a young man take down his father on CCTV. It was multiple rounds of shots to the head. Very cut and dry. Very interesting to see the case be thrown out due to incorrect police investigation. Eventually, got recharged with a lesser crime and served a few months in a mental institution. Story 15. Unless you're just looking for brief generalized answers, I recommend the book that John Wayne Gacy's lawyer wrote about defending him. It's fascinating and very well written. They knew each other before the crimes, too. Called John Wayne Gacy, Defending a Monster, by Sam Amarante, his lawyer. Answer: Sam Amarante was instrumental in creating the Amber Alert system. It was originally known as the Illinois Child Alert and Recovery Act, which he authored. It removed the 72-hour window that police used before in determining if a person was indeed missing and switched it to an immediate statewide alert system. He did this specifically because of his experience with Gacy and how slow police were to respond to the missing children cases. The attorney who defended one of the most prolific murderers of young people has ended up saving countless Ain't Life a Trip. Story 16. Somewhat relevant story, not a lawyer, but work in child welfare, and when I was a CPS caseworker, I removed a child from a murderer, got a call from law enforcement, showed up at the family home, law enforcement everywhere. They had literally just arrested this woman for takedown, and she was in the cop car while I was talking to the sheriff and helping the 6-year-old put a bag of his belongings together. Met with her at the county jail, floor-to-ceiling plexiglass between us, her in full shackles, where she was bawling and saying things like, "I can't believe they have me locked up in here," like some kind of killer and whatnot. Shortly after, I saw her again in juvenile court. As the caseworker, I have a front row seat in the courtroom, and she was directly in front of me. During a pre-hearing conference, she turned around to participate in the discussion, and our knees were literally about 6 inches apart. The rage in her eyes. Seriously, all I could see was her lunging at my, biting my jugular to eliminate me. She was cuffed. Don't worry. This didn't happen. Less than 2 months later, she was found guilty, sent to a women's prison. Fast forward about 6 months where I saw her. Again, turns out she was pregnant when she was arrested and had just given birth when I saw her again at the hospital, this time to place her newborn baby in state custody. She was cuffed to the hospital bed with essentially a taser bracelet around her ankle. Saw her again at the juvenile court hearing for this child, where she went off in court blaming me for her children entering foster care. By the end of everything, she didn't even try to claim her innocence anymore. Had continued saying she was innocent after found guilty. A few years back, her brother was also convicted of multiple take. Down here, the local paper did like a 4-page spread on this family and their criminal history, talking about the criminal gene and the killer gene because of the vast familial history of related violent crimes. Just crazy. Answer: where she went off in court blaming me for her children entering foster care, I'm sure the fact that she was convicted of takedown might have had a little to do with it. Joking aside, how does that work if someone has a child while locked up? Specifically, not so much a takedown or serious crime where they will likely spend the rest of their life in prison, but say something that might carry a smaller sentence where the person will clearly be out before the child is an adult. Is it up to the state as what happens? Does the prisoner have a say? I assume you'd try to find family that can raise it first. Story 17. Not to jack the initial question, but with this Larry Nassar case that is going on, I start to wonder about his lawyers. Like, how do you defend a child predator? I understand and believe fully that he deserves a fair trial, so he deserves representation, but I wonder how a firm takes that defense. Answer: the firm I work for charges those kinds of clients nearly double the usual felony-level retainer fee just to handle the case without going to trial. Then if the client wants to go to trial, they pay that fee again expenses. So one reason is the child rapist's money spends the same as a tipsy driver's, but we can demand a lot more money from the rapist than the tipsy for representation. Also, the attorneys don't have to agree with their client's actions in order to put up a solid defense that ensures the client can't wiggle out of their punishment through an appeal. Story 18. I'm a lawyer that works for a lawyer who used to do exclusively criminal defense representation. Early on in his career, he represented a guy that had eliminated his ex-girlfriend, and there was pretty much no denying the guy did it. So the trial strategy was to admit the client did it, but tried to get him off by claiming temporary insanity. Client said he has no recollection of anything. The details of the takedown were pretty grim. The victim was beaten, restrained, and was shot in the back after she ran outside. The DI